So why don't we dive in and let's start with really the basics. What do we mean when we talk about the pretrial system or the pretrial phase of a case? Well, the pretrial phase refers to everything that happens before a case is adjudicated. That adjudication can happen at trial, through a plea or otherwise, or charges, of course, can be dismissed. So anything that happens before that is considered the pretrial phase of the case. And that phase involves decisions by a whole range of agencies and entities, law enforcement, courts, defenders, prosecutors, pretrial services, and others. And given the number of agencies and people involved, that makes it a very complicated system to cover from a media perspective, but it is critical to cover it and to cover it well. And the reason is really because the decisions made at this stage of the case have significant impact on how the case proceeds and what the outcome is. And therefore also has all these impacts on individual rights, on equity, and on community safety and well-being. And there's a quote that I always like to use in these sorts of presentations from Berkeley law professor Caleb Foote, who in 1956 said, "Pretrial decisions determine mostly everything." And that is really backed up by research. And this relates to both the sort of at the individual level and at the system level. On an individual level, whether or not someone is detained awaiting trial has major impacts on whether they're found guilty, whether they're sentenced to incarceration, and how long those sentences are. And research also shows that unnecessary detention, even for just a few days, can disrupt lives, leading to lost jobs, loosened or weakened family connections, and in fact, even increased likelihood of rearrest in the future. And on a system level, pretrial detention is costly. The best estimate is that we spend roughly $14 billion a year detaining people before trial, and the vast majority of that cost is borne by county jails and county governments. And of course, the decisions that are made in the pretrial phase have major impacts on the safety of victims and of the public, as well as the long-term health of the community. So it's really for all of these reasons that in the last few years, pretrial justice has been in the news so much, often under the name, which I think is a little misleading, but the name of bail reform. But fundamentally, regardless of what you call it, what name it goes by, what is really being talked about is how do we get pretrial decisions right? Who should be released, and how do we provide support for people who are released and are living in the community? How do we provide the support that will help them succeed? And how do we identify the small number of people who need to be detained because they pose too great a risk to individuals or to the public at large, or too great a risk of actual flight from justice? And as you'll see today, these goals, overall goals, are shared by a diverse set of stakeholders. And the question, though, is really how do you design a system that achieves those goals? And the answer to that is complicated, and it goes well beyond simply what amount of money bond, if any, a judge sets at a first appearance hearing. And it's really further complicated by the fact that nothing triggers our emotions like public safety. And we know from lots of surveys and data that Americans consistently overestimate the likelihood of crime, that even when crime rates are down, people think they're going up. So what we want to know is really how do the people in pretrial systems, judges, prosecutors, defenders, law enforcement, and others, how do they engage their community in conversations around pretrial justice and provide them with the information they need, the public that is, to understand and to weigh in on those issues? And how do they ensure that the conversations that they have are based on facts and evidence rather than anecdote or emotion? And that's really where the media plays a vital role. You all shape the public's understanding of what people are willing to accept or not accept from their public institutions. And to be frank, there are a lot of challenges in pretrial systems across the country, and this is in no way unique to Washington State, though a lot of these challenges are present here. One of the first ones is that justice system agencies typically operate in silos without really a collaborative process to review practices or decide on changes. And relatedly, there's really no single appointed or elected leader who is overall responsible for the outcomes that the pretrial system produces. It's an amalgam of, as we've said before, independent judges, independently elected prosecutors, independent public defenders, right? Everyone operates in their own silo. And further compounding the difficulty in understanding the system is the fact that there's a severe lack of data nationally on what is happening pre-trial, even the basics. So it's hard to know how the system's currently working, much less what can be done to improve it. And as we'll talk about throughout today, one of the other challenges with the systems is that money is used as a default condition for nearly everyone who comes through the system. And money, as we'll hear, exacerbates existing disparities based on socioeconomic status and race. To put a finer point on it, Black and Latino people receive higher financial conditions, that is money bond, than white people who have the same criminal history and charges. But system change is hard. A lot of the practices that jurisdictions like Pierce and Thurston counties are looking to change, they're deeply embedded culturally. And so system change like this can be difficult. But how do we create a better system? What is really critical and what you'll see examples of today. What we really need is pretrial practitioners to look at their system as a whole, engage partners from all justice agencies to work collaboratively, and engage the community as well in this process. But they really can't do that without the media. And so we hope today's panels will spur some new thinking about how you cover these critical issues, and that more newsrooms will perhaps rethink and at least discuss how they cover crime and the criminal legal system, particularly at the pretrial phase. We also acknowledge and certainly understand, though, that local newsrooms are under pressure as never before, with a lot of newsrooms shrinking or closing, journalists being asked to cover more with fewer resources, and you have less time to meet with the people individually who are in or lead the institutions that you cover. But we're very grateful for those of you who are here today. Our goal with today's panels is to provide you with information and resources that can help you give your audiences more explanation, more context, more multiple source stories, and a heightened ability to differentiate between claims and evidence. So with that, we have 4 panels today that will guide you through pretrial systems here in Pierce and Thurston counties. While some of the things you'll hear are specific to these counties, there are many similarities to other jurisdictions throughout Washington and, in fact, throughout the country. The panelists will also provide their own perspectives on how they are approaching system change and what they see as the major goals or objectives of these pretrial improvements. So we will begin in a moment this morning's series of panels with a panel of distinguished judges. Our next panel will be comprised of other pretrial practitioners, so public defenders, prosecutors, pretrial services. Then we'll take a quick 10 or 15 minute break, and then we will have a session focused on data, since that is such a critical and sometimes confounding part of the story. And finally, we will conclude with a panel of people who've experienced the pretrial system in various capacities, including getting arrested and appearing before a judge and experiencing crime victimization. So before we get to those discussions, I want to give a brief overview of the legal principles that govern pretrial decision-making, because these are, or at least should be, woven throughout every stage of the process. And you have in your press packet a brief 2-page overview of some of these principles, which we'll touch on today, but that is a good reference both to the national legal principles and to Washington State's constitutional and statutory and court rules law that govern these decisions. So let's start broadly. For those of you in the room, obviously the screens are a little bit behind you. Let's start with the most foundational, which is the US constitutional provisions. The Constitution really doesn't directly address when a judge can order that someone be detained before trial. The only thing that's really explicitly in the Constitution that even touches on these issues is the Eighth Amendment's requirement that excessive bail shall not be required. Next. But that doesn't mean that we have nothing to go on. The Supreme Court has looked at other constitutional provisions, other elements of the Bill of Rights, and has held that the vast majority of people are entitled to release before trial. And the kind of central or seminal quote there is from then Chief Justice William Rehnquist in a case called U.S. versus Salerno from 1987, where he wrote, "In our society, liberty is the norm, and detention prior to trial or without trial is the carefully limited exception." And that really comes from the due process clauses of the Fifth and 14th Amendments, which state that no person shall be deprived of life, liberty, or property without due process of law. And of course, there's a lot of debate in our society right now about what freedom means and what freedoms it encompasses. But I think everyone would agree that physical freedom is among the most foundational and most central forms of liberty, which means you don't want the state to be able, in fact, the state cannot constitutionally take away that freedom, except in very limited circumstances, such as after someone's been convicted of a crime, or because, through civil commitment or otherwise, because of a clear threat to others or oneself. So pretrial detention is one of those places that it is a carve out from the general right, and that's why it needs to be so limited. There also, of course, is the presumption of innocence, and something that is just, I think we'll come back to a number of times today, is that people who are on pretrial status have not been convicted of a crime and they are presumed innocent. And what the Supreme Court wrote back in 1951 in another case, Stack versus Boyle, was that absent a right to pretrial release, the presumption of innocence would lose its meaning. In other words, if the state could arrest you and lock you up indefinitely without holding a trial, well, then what does it mean to be presumed innocent of the charges? You could be punished effectively without a trial. And what the Supreme Court has interpreted this to mean is really that there's a baseline right to pretrial release. That needs to be the default presumption. It can be overcome, but the kind of presumption coming in for everybody should be that they are entitled to be released before trial. So really what this means is that detaining someone before trial should be the last resort. And when it happens, it should only be in cases where the person is eligible to be detained under state law. And not only are they eligible, but there is no other way to reasonably assure that they don't flee and that the public or particular people in the public are safe. And I want to just emphasize the term reasonable assurance, reasonably assuring that they will appear and not threaten public safety. That doesn't mean absolute certainty. The only way you could have absolute certainty that someone won't do those things is to lock them up. Then we would be detaining everyone. And as we just saw, that is impermissible. So everyone who isn't detained, in other words, legally eligible, and there's no other way to mitigate their risks pre-trial, everyone else needs to be released with conditions, if any, that will promote court appearance and law-abiding behavior. So when we say conditions of release, there are a lot of different conditions depending on what jurisdiction has, but examples include pretrial services, court date reminders, money bond is one of them, location monitoring or ankle bracelets. There's a whole variety of them, but judges can choose which to assign in any particular case. Let's keep going, yeah. Or a couple more slides and then we'll get to the judges. So what I wanted to talk about now is just when judges are setting those release conditions, what are the legal principles that they follow? These are not direct quotes from these cases, but they are the principles that are articulated in those opinions. Salerno case, which we referred to before, talks about conditions being the least restrictive necessary to provide reasonable assurance of court appearance and public safety. In other words, you really need to think of conditions as a ladder from least restrictive to most restrictive. You start at the bottom with the presumption of release on recognizance, in other words, with just a promise to return to court and stay out of trouble with the law. And then you can move up that ladder if necessary, but stop at the rung essentially, where there is reasonable assurance of court appearance and public safety. The second principle from Stack versus Boyle is that conditions need to be individualized. In other words, you don't have across the board conditions that just apply to everybody. You need to look at the person, the facts of their case, and decide what is appropriate for that individual. So just again, really quickly on least restrictive conditions, this is usually in court rules, by the way, that conditions need to be the least restrictive necessary. The starting point in Washington's rules and in many states is release on recognizance. And as I said, if conditions are necessary, you kind of move up that ladder. And you don't want to jump to money bond, right? Many states consider that to be the most restrictive condition because it can result in someone being detained, which is kind of the most extreme outcome you can have in the pretrial phase. And again, individualized conditions have to be imposed based on someone's individual circumstances and likelihood of being successful before trial. These can be based on a lot of factors. Often they're enumerated in state court rules and laws. And if you're imposing a money bond, it really should only be imposed after determining what someone can afford. So just saying that if you're charge X, you have to pay $10,000 to get out, that doesn't make any sense, and it's not individualized. For one person, $10,000 is effectively an order of detention. For another person, $10,000 is, I pull that money together, I'm out tomorrow. And then just quickly on money bond, we call this financial release conditions, but it's commonly called money bond. Financial conditions, as with all conditions of release, they're meant to promote court appearance and public safety. The question is, does money do this? And the answer based on the research is quite clearly no. And there's a lot of research that shows that we can direct you to that, but the most kind of thorough analysis of this was done in a case called O'Donnell versus Harris County, which was from 2017, federal case out of the Southern District of Texas, Houston. And the judge actually held a trial on this, took expert evidence from both sides. And after reading that and receiving that expert testimony, looking at the data, the judge concluded that essentially imposing money does not incentivize effectively court appearance and certainly doesn't keep people from violating the law. So it doesn't achieve either of the aims of a release condition. And so, I know we'll wrap up shortly with this, but what a lot of jurisdictions are looking to do is reduce their use of money bonds. So there are two ways money is used right now. The one I was just talking about is the real release condition, the way you're supposed to, incentivize court appearance or even public safety. As we saw, that doesn't work. It doesn't actually achieve either of those goals. And instead of doing that, jurisdictions are moving towards pretrial services, which we'll talk a lot about today, where services are provided that actually help someone get back to court and stay out of trouble with the law. And then in terms of using money to detain people, setting bond at an amount someone can't afford, jurisdictions like Illinois and New Jersey in particular are moving to a system where judges actually outright make that decision. They say Matt Alsdorf is or is not such a risk to public safety, such a risk of flight that he needs to be held or he can be released, rather than making that decision dependent on whether or not I have access to money. All right, so that is, I know, was a lot to cover. But I just wanted to set the stage with the legal principles that really need to drive the decisions that are made before trial. So I would like to turn now to our first panel. We have three judges joining us here today. Judge Erik Price, sitting to my left, was appointed to the Court of Appeals in 2021 and subsequently elected in 2022. Prior to his appointment, he served 9 years as a Superior Court judge in Thurston County, where among many roles, he served as the chairman of the Thurston County Pretrial Justice Policy Team. Judge Raquelme, who's joining us over Zoom, was appointed to the Skagit County Superior Court in 2016 and 2017, and subsequently elected in November 2018. Prior to her judicial service, she was a senior deputy public defender with the Skagit County Public Defender. Today, Judge Raquelme co-chairs the Superior Court Judges Association Criminal Law and Rules Committee. And finally, Judge Skinder, also with us here in the room, was elected to the Thurston County Superior Court in 2016 and began his first term in 2017. Prior to his election, he was a deputy prosecuting attorney in Thurston County. He currently serves as Thurston County's presiding judge. So with those introductions, I will dive into the panel. Judge Price, I wanted to start with you. We've talked a lot about the presumption of release and the standard of reasonable assurance when making decisions about pretrial detention, release, and conditions of release. Can you talk a little bit about how judges weigh these legal principles and community safety when making decisions about detention or release and conditions of release? And, you know, in speaking about that, what do you wish was better understood by the public about how these decisions are made?
Well, thanks, Matt. That's a good question. As you were talking, I had a number of things that were coming to my mind, and I was like, okay, I got to remember all of the things I had to say for each one of your sentences. But I think overall, you know, I've heard that obviously that presentation about the constitutional aspect of pretrial detention, the presumption of release. And I think it's easy to hear that presentation and sort of go, okay, sure, I know that. But then in my personal experience, and it's been some years since I was on the Superior Court, it was probably 5 or 6 years ago where I was setting, you know, release conditions on preliminary appearances, but I did it for a number of years. My own personal experience in the community was it was those concepts that people really didn't tie to pretrial release decisions. I think in sort of the 10,000 foot level, people can, yeah, okay, I remember presumption of innocence when I was learning about my civics in 8th grade. But even my own friends who are, you know, thoughtful people would just focus in on the news stories about release and say, how on earth can this person be let out? Why are you letting anybody out? Why isn't everybody being locked up? And it would have, you would have to sort of get them to sort of process that next step, which is what we think about all the time in our decision making, which is that overarching presumption of release. So if you don't think about those constitutional presumption of release sort of concepts, it's very easy to get very linear in your thinking about release decisions and being very critical about anybody who's released. But we don't have that luxury. We have to be constantly thinking about that as we make these very difficult decisions. So that I think is, you know, if I were to say if there's one thing I wish people would take away, it's really ingraining that sense of presumption of release as they, you know, evaluate the multiple stories they hear. I mean, even, you know, this paper over the weekend had a front page story about a particular bail setting on a person accused of a crime. So you know, it's very fresh. So that's what I would say the number one thing I would ask.
Thank you. And can you say a little bit about how you look at it case by case, like what you're looking at in terms of individual decisions? I know this was a few years ago, but I'm sure you recall making some of those decisions.
Well, you have to really look at you noted this too in your presentation, the individualized aspect of the decision making. You really have to do what you can with very little information to assess, you know, what's really going to happen in the next 24 hours, 48 hours, or 6 months. If with this person, you know, sort of conceptually that the research says if you're detaining somebody who is not at risk to reoffend or not at risk for a violent offense, you're making things worse by keeping them detained. And if you're using a financial condition that if you decide that you might need to use financial conditions, you have to then evaluate, well, where's this person on the economic spectrum? Where is this amount of money, even if it's $500, is that going to keep them in? Or is $10,000 going to let them out? And so you have to balance that too, individualized to the individual. And then you know, what are they accused of? Where is that on the spectrum of seriousness for the community? What is their past history? You know, where have they proven a track record of they just can't follow court order? They can't come back to court. And so those are the main things that you're thinking about. And then it's an imperfect science. You know that you're going to miss some. You just do the best you can. One of the things too that and certainly Judge Skinner can talk about this, and your other panels as well. You're making all of these decisions usually within the first 48 hours of someone being arrested. There is a lot people don't know about these individuals. Law enforcement might have a 1-page, 2-page police report. The witnesses haven't been contacted, or many of them have. The drilling down into these individual circumstances of this individual hasn't happened yet. Defense counsel, very important role. They haven't had time to really engage with their client and understand what their personal story is. So you're making very, very difficult decisions of assessing this person's risk, either for failing to appear or for risk of violent offense, with very little information.
Well, thank you, Judge Price. And Judge Skinner, I want to turn to you and dig down a little bit deeper on that first appearance hearing, sometimes called the probable cause hearing. Can you say a little bit more about what that hearing is, what it looks like, what decisions are made, and what is kind of missed if a story focuses only on what the bond amount is?
I'm happy to do that. Good morning, everyone, and thank you, Matt, and thank you, Judge Price. So this morning, I just printed out the people that are appearing in Thurston County for our probable cause hearings today. We have about 30 people that are on, and that's in our district court and superior court. I'm doing that calendar today. And so what I'm trying to do as I prepare for that calendar is probably by noon, maybe by 1:30 or so, the prosecutor will file declarations of probable cause. Now that is a declaration that the deputy prosecutor, they've reviewed the initial police reports, and they have tried to put together why they believe probable cause exists. Probable cause, we hear that term a lot. The idea behind probable cause is, would a person of reasonable caution believe that there are facts that are being presented that would support that this person committed a crime? That's ultimately a judicial determination, but our system is built on checks and balances. So law enforcement initially, if they're out investigating an allegation of a felony offense, they make a determination. Does that law enforcement officer believe there's probable cause? If they do, they have the ability to initiate an arrest. When they initiate an arrest, then that triggers that they have to come before a court, like myself or any of our other courts throughout the state, in city court, district court, and superior courts throughout the state. And at that hearing, we're fortunate in Thurston County. We have some things that some of our smaller jurisdictions don't have. We have a really amazing pretrial services department, which is county employees that work to help people try to follow those conditions of release. So we have some structure in place to try to help that. Some of our jurisdictions in the state don't have that. But what the hearing itself looks like is the state files that declaration. We get a pretrial services report that will go through data that is helpful for the court in trying to make that individualized determination that Judge Price was talking about. And then we have a deputy prosecutor and a defense attorney. Now, the two of them will be in court either by Zoom, like you all are on Zoom, or they'll be present in the courtroom. The defense counsel is tried before the hearing. So on a Monday, like today, because it's a heavier number of people that were arrested over the weekend, we'll have 30 people on. So defense counsel is trying to meet with those clients in the morning. They will try to ascertain what the financial situation is of that person, because one of the rights that I'm going to inform everyone about is the right to have an attorney. That even if they can't afford an attorney, one can be provided to them in court. The other right that I always go over with individuals is their right to remain silent, which is a constitutional right. The right to counsel is so important because keep in mind, when someone's appearing on this probable cause calendar, they've not been charged with a crime. There has not been a charge filed. It requires the court to make that finding of probable cause, which then triggers in the court rule that the state has within 72 hours of the arrest to file charges or not file charges. It is not uncommon that the prosecution, when they look at a case, initially, they might ask the court to make a finding of probable cause. And then as they dig into the case, they determine we don't have enough to go forward. and they don't file charges. When they don't file charges, any conditions of release that I set for any of these 30 people evaporate, they go away. What has to happen for the conditions of release to remain in effect is the state has to make a filing decision within that time period. Now, at that point, the person's formally been charged with a crime. But for the hearings I'm having for these 30 people a day, they've not been charged with a crime at all. And so when I'm looking at what is an appropriate set of conditions to set for this person, I'm looking at many things. The presumption is they simply be released without any conditions except to come back to court. But a lot of our individuals, and this is where, again, I think we're fortunate here in Thurston County that we have a really great pretrial services that gives us some real data-driven information. That's our APPR public safety assessment, which again is a really helpful tool because it allows us to look at things that we know from a data perspective are important. Whether someone's going to come back to court, whether they are at risk to commit a violent crime. Those are the two factors that the court is always looking at. There are tensions in this system. And what I always try to make sure people understand, I could probably talk for the whole time and I don't want to do that. But what I want people to understand about our system is I think our system, our court system in the United States is the best system in the world. It has flaws. And what I always am impressed with is there are people that are constantly working to try to make our system work better and be better, because it can be better. But the reality is our system is great, because when Matt talks about the fact we could have a system that says simply the government arrests someone and they're held pending a trial. That's the rule. That would be a horrible rule if we think about all 30 of these people simply are held, whether the state files charges, doesn't matter. Whether a jury finds them guilty of the offense, doesn't matter. They're just held as long as the government says so. That's not our system, and it shouldn't be our system. We have a presumption of innocence in this country that is so important. But like I said, our whole system deals with tension, because we also are looking at, is the community safe? Is this individual that's before the court a risk to commit another violent offense? Are they a risk not to come back to court? And then we're trying to balance the rights of the individual versus looking at the entire system. We have a court rule that is very specific about how the court has to look at these things. And so for me, when I hear from the deputy prosecutor and I hear from the defense attorney, they're going to make what they think the conditions of release should be. And again, they've had very limited time. Defense counsel usually has had a half day at best. The state also a half day at best. And as we go through the process, that if the court finds probable cause, sets conditions of release, then if charges are filed within that 72-hour period, then everyone starts to learn more about that individual. They learn more about that case. And then we get to the things about the right to trial and all these other things that are so important. So the thing that I'm always, when I talk to friends and family and neighbors, and they get focused about consequences, that's what they'll tell me. They'll say, well, this person there should be some consequences for what they did. And I'm like, that's not this phase of the process. This phase of the process is simply, is there probable cause? And then what conditions can the court set that comply with the Constitution, comply with the court rule? Consequences come far down the road. If a case is charged, if someone pleads guilty, or if a jury finds that person guilty of a crime.
Thank you, Judge. And we'll turn in a moment to Judge Wilcome, who in Skagit is in a smaller jurisdiction. We can hear a little bit about how it differs there in terms of the options that are available to judges. But before we do that, I wanted to ask both of you, we can start with Judge Price, a little bit more about money bond or financial conditions of release. So I talked about that a little bit when we were talking about the pretrial legal principles, but basically when it is used as a condition of release, money is meant to incentivize people to return to court and remain arrest-free. We saw earlier that actually, there is no evidence that those financial conditions do that, but it is also used as a means to detain people. And before turning to you, judges, I wanted to just highlight how the direction in which a number of states are moving nationally. A lot of states are beginning to move away from the use of financial conditions and the use of financial conditions to detain people specifically. So for instance, Illinois recently eliminated money bonds entirely from its system. And now judges make actual in or out decisions based on evidence from the prosecution and defense about whether someone is detained or released. Washington doesn't have this intentional system of detention, except in very limited cases, those charged with a crime carrying life imprisonment. So money continues to be the primary way that people are detained throughout the state. So I'd like each of you to talk a little bit about what are the challenges that judges face regarding using money to detain people, as well as using it as a condition of release. And do you have other, I think you started to talk about this, Judge Skinder, do you have other conditions, or what are the other conditions of release that can be an alternative to money? So you can answer in either order.
Well, I'll just say that there's a lot to like about an in and out system. I have spent some time with at some national conferences in which that type of system is discussed. There's a lot to like about it because it's an honest system. There are certain individuals who the danger is, even though they haven't been convicted, even though they haven't actually even been charged, there are certain individuals and certain set of allegations that I think everybody knows this is not someone you want turned around and released. And you're left as the judge in a difficult situation of trying to assess with really very little tools to have this person not necessarily released. And so you're trying to figure out a money level. And yet, as the decision maker, the science, which says money doesn't help. If I were to give someone a very high amount of money, they make that bail, they pay it, and then they're out, is that money really going to prevent them from doing something bad or to return to court? The science says no. So, and at the same time, as a judge, understand that certain marginalized communities have difficulty with finances. So you want to make sure that you're not setting bail an amount that's that allows a wealthy person to get out, or a poor person to stay in simply because they're poor. So I like an in and out system. I think it's a more honest system because and then the decision maker can say, you know what, I don't have to worry about whether this bail amount is going to allow a wealthy person to get out. I don't have to worry about whether or not an impoverished person is going to stand simply because of money. I'm making that decision based upon my assessment of a risk of violent offense.
And I have heard that in talking to judges in Illinois that they express gratitude that they're actually adjudicating the issue before them, that they're explicitly having the conversation, hearing real legal arguments about release and detention as opposed to having it couched in terms of money. Judge Skinder, what would you add from your experience?
I think the biggest thing is that starting point is that the court, defense counsel, prosecution, they all have limited information at that first hearing, yet we're making this really critical, important decision. And so we have the least amount of information and we're making this very critical decision. Let me go, and I don't disagree with the things Judge Price said at all, but we do have a rule and we have to follow that rule. And so from the court standpoint, we're looking at any other condition of release. If we think conditions need to be set, we're looking at things other than monetary bail first. So we're looking at all the things that I think most people have heard something about, that this person, if I have one of these 30 people before me and I'm saying, okay, you're going to be ordered to have no criminal law violations. You're going to be ordered not to possess any weapons. You're going to be ordered to have no contact with the geographical location or with the people that are involved in these allegations. You're going to be ordered to report to our pretrial services. You're going to need to come back to court as ordered. I'm going to give them that next hearing date and time. And if they're not there, what will happen? That you can't leave the state of Washington without court permission. There might be other individualized conditions that are set, and why those conditions of release are so important. And what I tell people is this, and I go through them all and I explain them. If someone doesn't follow those conditions of release, then it gives the state the ability to bring that matter back before the court. They can bring it back and they can say, they would file something and they would explain, Your Honor, the court set this condition, it hasn't been followed. We're now asking the court to modify or revoke conditions of release, which means instead of the person remaining out of custody on those conditions, that the court could then impose new conditions, more conditions, could add a monetary bail, could increase a monetary bail, or could simply say, you know what, you have shown you cannot follow these conditions of release by a very high standard, and therefore the court's going to order that you be held. And that is really important. Again, we have an adversarial system of justice. This is where the prosecution brings that information forward. But the conditions of release, those are something we go through, and research shows, and that's the thing that's important for people to keep in mind. The research shows that most people, the vast majority of people, follow those conditions of release. And I think, again, it's my sense is, and I hear frustration sometimes from people where they think that's not the case. They think most people don't follow their conditions of release. The reality is most people come to court. The reality is most people don't commit a crime while they're on conditions of release. Now, we also have to focus on those situations where someone does violate the criminal law while they're on conditions of release, or who don't come to court. And so, but what we're dealing with there is a smaller group of people that have shown they can't follow the court's condition, and then the court has the ability to change things. This is also similar, again, just to try to give how our system works. If the court were to set a set of conditions that included a monetary bail amount, and Judge Price is concerned that based on the limited information he had, he set the best amount he could, and the person wasn't able to post that, the defense has the ability to bring it back before the court and say, you know, the court made this decision at that first preliminary appearance, that probable cause hearing. Now we have more information, and we have a plan that we think would work better than what the court did initially based on the very limited information the court had. So our system has flexibility to it, and it relies upon both the prosecutor and defense counsel to bring those things to the court.
Yeah, I would just add to that too. One of the things, Matt, that you said in your introductory remarks was how the system, the pretrial system is a collaborative system, not collaborative, but it combines various stakeholders with doing their jobs. Yeah. Right. And I think some of the things I see in the media stories, it's solely focused on sort of the end result, that decision that was made. And I think if I were to ask of the media, I'd say, you know, have as you write your stories, an appreciation for all of the various parties who are doing their jobs and their roles that culminate in this, in the what's happened with this particular individual. And that includes post bail setting opportunities to sort of revise the decision that Judge Skinner's just talking about.
Thank you both. I'd like to turn to you, Judge Palme. You are in Skagit County, and it's obviously a smaller jurisdiction than Pierce or Thurston. And I'd like your perspective on, you know, how your options differ as a judge, your options for how to deal with or assign conditions to people who come before you, how they differ from jurisdictions with perhaps more resources like Pierce and Thurston. You know, when you make decisions about conditions of release, what are your options?
Thank you. So I think some of it starts even on the front end, like what Judge Skinner was talking about, how this morning the attorneys are kind of frantically working to prepare the cases for this afternoon's calendar. They're doing that today in Skagit County as well. But what we don't have are those assessments. And so what happens is that the prosecutor is pulling up the criminal history, at least to the best that they can access it, because the national data takes a little bit longer to pull up, but they'll pull up the criminal history. Maybe if they see that the person's being supervised by the Department of Corrections, they might reach out to DOC to find out what's going on there. And so it's a little bit more of a hands-on approach where they're coming up with all of this information. There isn't kind of a third party coming up with an assessment. The defense attorney is doing something similar. They're looking at their client's criminal history. They might be looking at the history of the case, because sometimes when, you know, it's not just people on new charges who are getting arrested, it's people who didn't show up for their court dates that they were required to appear at, and then a warrant issued, and now they're arrested over the weekend. So they might be looking through the file to get a sense of what happened on the case. Is this the first bench warrant? Did they fail to appear on a summons that they might not have actually received? And so, they're going through and they're trying to sort out all of this so that when they come to court, they can put all of these things in front of the court. The defense attorney is probably also trying to, if they have time, talk to family members. And my screen just kind of glitched out, so hopefully you can still see me. I'm not sure what happened there. Oh, there it is. So they might be talking to family members to establish, my client has all these connections with the community. Here's their support. This is where they're going to live. They've got this job. They probably don't have a whole lot of time to reach out to third parties because they're so busy talking to the clients, getting ready for court. And so some of it is even shaped by the information that we're getting at the time of that first appearance. Because in some other counties where they have a pretrial services department, they also are providing these risk assessments. And sometimes the risk assessments might not come up with any more information than what I just described that the attorneys are already trying to pull, but they might come up with other information. I don't know. I've never actually worked with the risk assessment tool. So I'm speaking a little bit from a vacuum there. But then when we're actually getting to that point of setting the conditions, we still can set conditions, just like all the conditions that Judge Skinder just went over about, not having contact with certain people, not possessing any firearms, any of those kinds of things. But then we also are looking at possibly setting a financial amount as well. And we don't have a pretrial services department. And I would say that most counties don't actually have a pretrial services department. They might offer maybe one or two things that would be considered pretrial services, but not like a whole panoply of pretrial services like what I know Thurston County has. And so let's say someone is released on their own recognizance, and that is the presumption of release. If they're released, but we still set those conditions, there's not really anybody to monitor those conditions or to remind the defendant about those conditions, other than their attorney, who they may or may not be having contact with. And so, what I've noticed sometimes there might be a condition to have some sort of additional monitoring, like a scram device that monitors whether they're consuming alcohol and if that's in their system. Well, sometimes what happens is the report for that, if there is compliance or a violation, that just gets put into a court file. The agency will just put it into the file. It would be the equivalent of somebody walking into your office, into a filing cabinet, and just sticking a piece of paper into a file that no one knows got added to the file. So the prosecutor doesn't know, the defense attorney doesn't know, and even if they did, I'm not really sure if it would be their role to be initiating something, and the court doesn't know. And so we might not find out until their next court date, when the prosecutor is kind of looking around at the file and realizes that this thing got stuck into the court file that nobody knew about. So it's pretrial services I see as being a very helpful tool to make sure that these conditions that we set are complied with. And really with us, we are setting the same conditions that are being set in the other jurisdictions that were just mentioned, but whether there's actually some follow through on that is very much up to the individual.
Right. Thank you, Judge. And we just have a few minutes left. If you have questions, please do add them in the chat. In the meantime, Judge, I did want to ask you a question in another capacity in which you serve, which is that you're co-chair of the Superior Court Judges Association Criminal Law and Rules Committee. So can you just let us know, to what extent has that committee been involved in discussing pretrial issues?
Sure. And I will just clarify, I just finished serving in that role for 5 years. So as of 6 days ago, I'm no longer the co-chair of that committee.
Emeritus.
Emeritus. So we've obviously this is a big issue, and we've had a number of discussions about it, and all the things that everybody's grappling with. I think where everyone keeps landing is that pretrial services would be very helpful. I testified in the legislature a couple of years ago, and I was asked, well, why don't more courts have these pretrial services? Well, for one, funding, but also if that was under the court, I didn't go to school for that. I went to school to be a lawyer and and then was trained in how to be a judge. I am not a specialist in pretrial services or what best practices would be, how to implement something like that, where the funding sources are. That's very specialized. And so there's actually a pilot program that got funded by the legislature 2 sessions ago, and that's being run under the umbrella of the Administrative Office of Courts. And that's to pilot some pretrial services programs in several jurisdictions around the state, just to get a sense of, okay, well, what can be done, and what are recommendations for jurisdictions of varying sizes, and to perhaps help that effort move forward, so that that's not just, you know, if you're in Pierce or Thurston or a couple of these other counties that have more robust pretrial services programs, so that more counties have the ability to get these programs off the ground. So I know that that's, you know, it's been an ongoing discussion, and but that's where the direction that some of that has led.
And Judge, is the committee looking at that on its own, or are you pulling in other stakeholders to advise on those sorts of questions?
Well, and I know that there is a separate group, and I was looking through to find the name of it, but I know that there is one of the judges in San Juan County, actually, I know, is involved in a pretrial release group, and I think it's more of a stakeholder group, and I was just trying to get a little bit more information about it. But basically what I know that we've decided over the many years of discussing this is that this isn't just something that a group of judges can sit down and figure out. There need to be more people at the table than that, and I know that there have been a number of efforts over the years to pull something together.
So we need to wrap up in just a couple minutes. So to close, I just wanted to round robin to the 3 of you judges, you know, something directly for the reporters and journalists in the room and on Zoom. Obviously, judges can't talk about pending cases or talk about their decisions made from the bench. So what advice do you have for reporters who are covering the courts? What can judges discuss? What should reporters be thinking about? Just quickly for each of the 3 of you.
Okay, well, I'm going to actually answer a question I'm not sure that's asking.
Okay.
And that is, the one thing that occurred to me that I want to make sure I get out there is that I think, even again, going back to my hypothetical thoughtful friends, a lot of them say, you know, hey, as a judge, why are you not worried about community safety? And I think the answer I would have is we're worried. We're very, very concerned with the fairness to individuals who are in front of us, and we're also very concerned with community safety. And I think it's easy to look at community safety in the near term. And you said something, Matt, earlier. You said, hey, look, the safest thing maybe in some people's minds is just to hold everybody. If you hold everybody, you're not risking any further criminal activity from that particular individual. That's a near-term view of community safety. And I think what the research shows us is if you hold the wrong people, you're making things worse from a community safety perspective. And this again goes back to your point that people lose jobs, they lose relationships with families, and a particular individual who should not be held is held. They are more likely to be a problem for community safety down the road. So in the long term, we're actually less safe when we hold the wrong people. And so I think if we can get sort of the public and the media to think about community safety a little bit differently and think about it in sort of a macro sense, I think we can, you know, there'll be a better appreciation for what we're trying to do with our pretrial services, but the roles of the defense and the prosecutor and the decisions they're making as they bring it to judges. And I think if you have more of a macro view, it's easy, I think, to get myopic when you look at it from a media and you got a particular story and a particular individual. But if we all have a better sense of community as a whole and community safety and the big picture, I think we'll all have a more informed discussion in the meeting.
Thank you, Judge. You answered a better question than the one I asked. So thank you. Judge Skinder.
Well, I guess I would just say, you know, I appreciate the media being here. I appreciate the efforts to get more educated on what I think is really a complex set of balancing all these competing interests and tensions and how to do that. It strikes me that media is overwhelmed right now. I think there are very few reporters that are covering day in, day out because there's just not enough media to be able to do all of that work. I remember when I started, I've worked in the court system in some capacity for 28 years. And I remember early on, we would have a reporter in every day on the criminal calendar in court, maybe not for every hearing, but they would be present every day. And so I think it's hard to cover these stories, but I guess what I would ask is to try to, you know, we're fortunate, again, we have really good local media representation that I think when they do a story on a case, they try to get into some of these details that we're talking about what was requested of the court by both sides, whether there are other people in court that spoke, what they said, and then trying to also give a little bit of attention to what the judge actually ruled, as opposed to simply having that one sentence, whatever monetary bail was or wasn't. And so I guess to me, all these cases, they're all people's lives, right? I mean, everything that we deal with in court to me is so compelling because we're dealing with people that sometimes these are incredibly sad, heavy cases that we deal with day in, day out. And so I think where the media serves such an important role is being able to shine a light on those stories because they're compelling stories. I don't think it's as compelling when there's just, a very short explanation, the court did this or that, without having some of that aspect of what was going on in the court hearing and what's going on with that particular case. So to me, the stories that I find compelling are the ones that kind of get into some of those details, but I know it's hard.
Thank you, Judge Skinder. And finally, Judge McCall, anything to add to what the judges have said so far?
Yes, I'd like to just kind of join in on that comment that Judge Skinder made about the media, and I know that things are challenging right now. We used to see a reporter. We always knew who was on the court beat because they were in the courtroom all the time, and they knew all of the players. They knew all of the attorneys. They knew who to walk up to after a hearing. They would get more information, and they would get it pretty much in real time. And I know that that's just not the reality of working in the media these days. That that budgets are really tight, and you're stretched really thin. And I don't normally see a reporter. They might be observing on Zoom because we do have Zoom on in the court where I am, but normally they'll label themselves as a reporter when they're on. And so I'm not even seeing that a lot of the time. I think that what's happening is they're reviewing the files after the fact, and you miss some of those nuances. And I know that it takes a lot of time, but especially on those, bigger cases that you think that need highlighting, might make sense to go back and listen to the recording or talk to the court reporter about getting a transcript, because there are more things that happen in those hearings than the clerk's minutes reflect, or that final order reflects. Who knows? The prosecutor might have even been agreeing to release that person, but you might not be able to tell that just by looking at the court file. So there's just a lot more nuance that goes into it. We make findings. We have things that we're required to say. If we know that we're setting a bail amount, we have to find that there's a likely danger of committing a violent offense, not just offense or, crime against the public, but violence. And or that there's a substantial likelihood of failing to appear. And so there are things that we're looking at and that we would articulate in court that some of you, especially people who might be newer reporters, have never been sent to sit on a regular criminal calendar. You might not even know that the judges are routinely doing, but that's what's happening. And so I would say, particularly if there's a larger story, I know you can't do it on every single case, but you really should either be attending those hearings or following up on them and talking to both sides, not just one of the sides, but to both sides of the attorneys who were in court to get a better sense of what actually happened and what the posture is of the case.
Thank you, Judge. So we have to wrap up there. I know we could talk about this obviously for the full day if we had the time, but I just want to conclude by thanking Judge McCall, Judge Price, and Judge Skinder. Appreciate your participation today, and we will not take a break right now. We will be inviting the next panel of panelists up to join me now. Thank you.
Thank you all very much.